Hello and welcome to the Arbitration Conversation. So in this episode, we have a real treat here. We actually have the blues lawyer, otherwise known as Aric Garza. Mr. Garza has a very active practice as an arbitrator, a mediator, a lawyer, and a blues musician in San Antonio, Texas. So what's going to be great about this webisode is we're going to talk about consumer arbitration. You know, consumer arbitration, it's gotten kind of this bad rap in the news and politics, but you know what? Sometimes it actually can work very well. So Mr. Garza is going to share his insights and ideas. We welcome you to this webisode. Thank you.
Thank you for having me. I appreciate it very much.
Well, this will be fun. So first of all, could you explain just a little bit about your background and how you got into doing consumer arbitrations?
Yes. Well, I've been a litigator for about over 20 years, and about 7 or 8 years ago, I found myself as an advocate in a case in which I was forced to go to arbitration. And I thought, well, let me figure out what's going on here. So I attended a CLE on arbitration, and I found it fascinating. And afterwards, I asked one of the persons involved with the American Arbitration Association, how does one become an arbitrator? And before I knew it, I went through the process, and about a year later, I became an arbitrator, and I've handled quite a few consumer cases and commercial cases since then.
So what's different though about consumer cases as opposed to commercial cases, especially how that works with respect to the American Arbitration Association?
Well, in particular, commercial cases happen to be business versus business, business to business. But in this particular case with consumers, generally speaking, a class of types of disputes fall under a consumer type of arbitration. For example, the purchase of an appliance, or one in which there's an individual, a consumer, and a business involved. And there's a category of transactions that cover consumer arbitrations. But generally speaking, that's the major route. Sometimes the parties agree in their agreements to use the consumer rules of arbitration, despite the fact that it's one or two of them are small businesses as well.
So how about you in particular? Could you give us an idea of some of the types of cases you've handled?
Yes. Generally speaking, they're going to be under federal laws like the Telephone Consumer Protection Act or the Fair Credit Reporting Act, you know, the Robocall Act, as I mentioned, those types of cases, but also breach of contract claims, claims that, I'm in Texas, so we have something called a Deceptive Trade Practices Act claim, but consumer type claims are generally what are covered, and then ancillary claims as well.
So what kind of things, as an arbitrator, do you have any sort of insights, tips, or thoughts about being an arbitrator when you do have consumer cases?
Yes, I do. Oftentimes the cases I have will involve attorneys that are excellent from great law firms, have great credentials, but some of them tend to not have had arbitrations before, and in particular, they haven't had consumer arbitration experience. They don't have that kind of experience. So one of the things to note, at least from the AAA, because I'm an arbitrator with the AAA, is that their rules are very, very concise. It's not a huge giant, you know, the federal rules of procedure or the federal rules of evidence. They're meant to have a very expedient, efficient type of dispute resolution process that contains costs. That's their principle, their guiding principle. Of course, there is the balance with due process, but at the same time, the goal is to try and get a quick resolution that addresses all the needs of the parties. So one of the primary things that practitioners should note is that motions, summary judgment motions, dispositive motions, pleadings in general, are not permitted under those rules. You have to ask for leave of the arbitrator before you start filing motions left and right. Obviously, the goal is to contain costs. The discovery process is not really defined in the rules. So the parties are not generally permitted to conduct free-for-all litigation type discovery. But oftentimes that's what they do because they feel that they want to litigate the case. So I think one of the biggest parts to know if you're a practitioner, certainly if you're involved in a consumer arbitration, is that there's going to be an exchange of information. But requests for production, interrogatories, depositions can be utilized if the parties want to agree to that, but they really shouldn't because there's no need to. It's just a matter of submitting the claim, exchanging the information, and getting on with the final hearing. And really what you're entitled to in a consumer arbitration are three things, and when it really is boiled down to. The first is a preliminary conference in which the parties identify their claims and come up with a scheduling order. The second is the final hearing, which generally is 1 day, but it can be more than 1 day. And then a reasoned award. Generally, it's going to be a concise reasoned award or concisely written one. Other than that, I mean, that's what your fees entitle you to. Other than that, you're going to be spending more money on the case. And that's where those fees get driven up, at least on the administrative side.
Do you find that, so those are some really great points, and I really like the way you broke that down with the three main pieces, but I'm wondering if there's any sort of different advice, depending on, if you're talking about an attorney versus a party being a consumer, kind of as they approach these arbitrations, are there any like specific advice maybe for the consumer?
Yes, I think a lot of the information can be found on adr.org, at least as far as the AAA is concerned. And there are some specific pieces of information for people who find themselves in a pro se litigation where they're representing themselves. And in those situations, the filing fee is $200. After that, the arbitrator costs and the administrative fees are generally borne by the business. And even if the parties have an arbitration clause, if the amount in controversy falls within a small claims court jurisdiction in their state, for example, in Texas right now it's 10,000. I think it's set to go up to 20,000. If that's the case, then you don't have to use an arbitration. You can go to small claims court. So you should note that. What else? The person that's going to adjudicate your case is generally going to be someone who is, if not an expert, a very seasoned attorney, an experienced attorney who knows a lot of the area of law that's covered by the dispute. The other thing is that case managers that are involved in the situation, of course, they cannot give you legal advice, but they can provide information that's available generally on the website. And so, I have had pro se litigants before me in arbitrations, and, clearly an attorney is beneficial, but it's not as if you cannot do it in a pro se manner.
Yeah, I mean, that's the thing, especially with it being less of the sort of formality of court. I would hope that it would be less stressful as well, given that. And the other piece that you brought up, which I think is important to understand about arbitration, is that you do have an expert as the arbitrator, right? And when you are accepted to be an arbitrator with, for example, JAMS or the AAA or any other reputable provider, then you've already surpassed certain obstacles. You already have shown that you have the background and experience, which I think is a really important point about arbitration that sometimes we don't sort of stop and think about, which is really, really good to think about. Are there any other thoughts you wanted to share about consumer arbitration? Do you find with the pandemic, have there been an increase in cases or decrease or about the same?
Frankly, I don't know, but I think in different areas. I think in employment cases, there's probably been a spike because of the fact that many people have been displaced because of COVID-19. Certainly consumers, well, the arbitrations are now taking place just like this, just exactly like this. I mean, it's so much easier. You don't have to go to a formal conference room and you don't have to appear in front of a judge. The AAA recently passed, or not passed, but promulgated some rules for Zoom arbitrations. They have protections in place for sharing sensitive information. So there are those protocols for against cybersecurity and things like that. And you hit upon something else, Amy, with regards to the persons who preside over the arbitrations. If you think about it, many of the judges that preside, especially in major cities, the dockets are full of family law cases and other types of cases. And not that the judges are not learned or experienced in handling commercial and consumer cases, it's just not on their docket. Most of the time it's divorces, it's adoptions, it's custody, child support. All of those things are primarily what many of them see. And many of the judges even that are elected have that as their background. But with an arbitration, you have the appointment of a consumer arbitration. You don't select them, the case managers appoint them, and they generally appoint people with experience in that particular dispute. So that's very beneficial, and it helps everything. It helps move the case along faster. It helps contain costs. It helps level the playing field for the consumer. And the costs of $200 are less than the filing fee of a lawsuit, I can tell you, in San Antonio. So there are many, many benefits. As far as for practitioners, I would just say this, a couple of things to know for practitioners or advocates in arbitrations is that it's not litigation. You're not just litigating a case in an arbitration. You're arbitrating a case where you just provide the information. There's no need to send reams of information unless it's absolutely critical, and just get to the final hearing, because chances are the arbitrator has heard and seen that issue before.
Yeah, really good points. Even in practice as a young attorney, I remember learning that lesson very well, that just, an exchange of information. We don't need to have the sort of formal discovery that you see in a court of law. And, it can help with efficiency, just getting the information you need and providing a just resolution. Well, listen, this has been a great conversation. And I would ask you to play your guitar, but I will, I'll spare you. I wanted to thank you again. Thank you so much for taking the time with us today.
Thank you very much. I appreciate it.